call the failed minutes. Hear ye, hear ye. I'm Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States, the State of Michigan, and this honorable court. Good morning, and welcome to the second and final day of oral arguments in January. We have this morning 3 arguments on application, which means that each of the parties are allocated 15 minutes to make their arguments, the first 2 minutes of which are delivered to you question-free. We have read your briefs, and I encourage you to use those uninterrupted first 2 minutes to talk about the outcome determinative issues that should persuade the court that your client should win. And with that, I'll call the first case, People versus Duenaz. I think that's the way it is. How is it pronounced?
Pajak. Was that what you were saying?
No.
Your client.
Never mind. Continue. State your name, please.
Good morning, and may it please the court. Christine Pajak, State Appellate Defender's Office, on behalf of Mr. Duenaz. This court should grant a new trial to Mr. Duenaz because the trial court erred in excluding the evidence of the complainant's prior sexual assault. This is true whether the issue is viewed as one of statutory construction or as a question of constitutional law. Prosecution in either instance cannot meet their burden of showing that the error of excluding the evidence was harmless. Turning first to the definition of the definitional question, which I know has been before this court several times, sexual conduct should be understood as something that a person does, not something that is done to them. This is consistent both with the definition and the purpose of the statute and the structure within the statute, differentiating between conduct and activity. With respect to the Confrontation Clause issue, Hackett says that there's a right, well, recognizes that there's a right to confrontation, and Morse has, I think, narrowed this too much, this as applied in this case. The error was not harmless. I wanted to back up, too. I forgot to ask for 2 minutes of rebuttal.
You have to manage your own time, though.
Thank you. And, of course, I would welcome questions, actually, at any time. I don't know where we are here with the yellow light, but if I could turn then back to, if there are no questions, back to the question of sexual conduct and sexual activity. As you look at the statute, what you have is, whether you understand it as behavior or not, it's something that, conduct is something that a person does. And the purpose of the statute was to keep the courts and juries from improperly focusing on a wide variety of things that could be considered sexual conduct, the manner of dress, the flirtation, other actions that a person had done, and to put people who are the victims of sexual assaults more on, to be treated more like the victims of other violent crimes, which is what they are. When you look at the statute then talking about sexual activity, they're talking about very specific instances of things that could be considered sex, if you will. Sources of disease, semen, and pregnancy are all, very narrowly targeted. And the change in the language of the statute during the drafting process to eliminate consensual sexual activity and broaden it to talk about sexual conduct gets at that very purpose.
Counsel, even if you're correct as to the broader definition of sexual conduct, the excluded evidence nonetheless needs to be relevant. What is the relevance of the sexual conduct evidence that was denied you in this case?
With respect to this particular case?
Yes.
The complainant, when she came forward, or actually was questioned, was very young, at the age of 7. There is what's been termed a sexual innocence inference theory, which is that somebody who is that young wouldn't know about such things unless something had happened to them. 7 certainly falls within that range. So
well, the prosecutor didn't raise the age inappropriate issue. I guess my question then is, she was 12 years old at the time. What specifically was age inappropriate about her testimony?
Well, with respect to her testimony at 12, nothing, right? I mean, at 12 years old, you would expect possibly a little more information. But at 7, which is when she came forward, you are still talking about that particular age as being...
That evidence, those statements that she'd made when she was 7 or 8 had been introduced, is that right?
You're right. And, of course, the fact that she was 7 or 8 at the time was also before the jury. And just like jurors aren't supposed to check their common sense at the door, the court should not either. And the common sense view of people is that if you're 7 years old, you really shouldn't know any of the mechanisms of sex.
But given that the prosecutor didn't raise the issue of age inappropriateness of the statement, it really has to appear to be such on the surface. In other words, the members of the jury hearing this might have would have had to have raised in their own mind the issue of age inappropriateness. Is that right?
In this particular instance, while there weren't explicit statements, if you look at it in total, it is certainly underlying much of what the prosecutor is saying. The other part here is not just the complaint.
Would you explain that last statement?
The questioning, the manner of presenting it to the jury. I mean, so they're not saying how well. So there's no explicit statement. How else would somebody of this age, have this information? But the way the case was presented certainly draws to it. And if I could get back to the other point I wanted to make with respect to this is not just with respect to the complainant's testimony, but also with the ability to question Dr. Fredrickson with respect to evidence that was presented about urine leakage, the only possible relevance of which would be to suggest that this was a physical manifestation of an injury.
Wasn't the expert testimony that there was no necessary relationship between urine leakage and having been subject to sexual abuse? I mean, if that's true, again, my question would be, what's the relevance of it?
Well, the question then would be, why was it presented to? If it's not relevant, it wouldn't be presented to the jury. So the purpose of presenting it is obviously is to support the prosecution's case, which is jury draw your. It's not necessarily true.
Except the actual expert's testimony was spectacularly unsupportive of the prosecution. He said none of the physical evidence is necessarily tied to any physical sexual assault, didn't he?
But what he also said is that there are studies that would show that it doesn't in this particular, they're not specific to this. That's my recollection of the testimony.
But you also argue that the denial of the admissibility of the evidence concerning the stepfather's abuse was something that was prejudicial to your interest here. And I guess I'm wondering about that, too, since it was, I think, the mother's testimony that the child's changes in behavior only came into being after the later alleged rape, and that the stepfather's abuse really had nothing to do with the apparent change in her behavior.
The testimony, I think, the testimony was that she had been, I guess, her normal self up until the point that she was asked about this incident and revealed it, would be the way to phrase it. There was no exploration of whether or not there had been earlier behavioral changes and at what point they're viewing her as a happy-go-lucky kid. So without being able to question the mother about whether or not there had been other behavioral changes earlier, that is part of the problem here and part of the harm with respect to the ability to confront the witnesses and present a defense. This is not a case where, there was a lot of other ability to question it. There's no alibi. There's no physical evidence that would support the prosecution's case in the sense of DNA.
Other than the absconding of your client to, where did he go to?
He moved to Arizona.
Moved to as soon as these
Well-
allegations, and a conviction in Arizona for sexual, and other witnesses who testified of similar sexual assaults. That's pretty significant body of condemning evidence, isn't it?
But not specifically with respect to the allegations in this case. I mean, there's no support for that for the particular complainant, and that is where the harm comes in, because Mr. Duenaz was not able to question fully the witnesses with respect to this particular case.
But it does go to whether the error, if there was an error, was harmless, does it not?
Well, it would certainly go to it, but of course it's the prosecution's burden to show that it was harmless beyond a reasonable doubt. And given the fact that the defense was limited in this way, they did not meet their burden.
Okay. Then you can, if there are no further questions, you can reserve the remainder.
How much time do I have?
Unless you have something else you would say.
What's that? I'm sorry. I mean, I could talk forever about the issue of sexual conduct and sexual activity.
But we don't want people just to talk.
I
If you have a purpose
understand
in
that.
talking now, that's fine. Otherwise, reserve your time. And
I'll reserve my time. Thank you.
thank you.
Good morning. May it please the Court, my name is Hillary George. I represent the people of the state of Michigan in this matter. I would welcome questions like my opponent did at any time, but what I wanted to touch on were just a couple of the things that she said.
But, counsel, if it's okay, I would love to just go into the issue that's really what I've been focusing on as I've been kind of weighing this. And what I like to do is kind of look a little beyond this case, because I think there are some far-reaching issues. And what I like to really kind of pose to you is kind of this type of a question. When we're dealing with the rape shield, when we're dealing with the issue of involuntary conduct, if you could help me balance this, and this is what I struggle with. If you have a situation where there is relevant evidence that could potentially exonerate an accused person who's on trial for their life, that evidence should not come in, because why?
Your point, Justice Bernstein, is well taken, and I think that the Rape Shield Act can and should yield in certain circumstances to evidence that the defense needs to either present a defense or to confront. But mechanisms are already in place for that. We don't need to strip away the protections of the Rape Shield Act from victims of sexual assault just to preserve the defendant's rights to confront and to present a defense. That's what the Hackett case is there for. Beyond Hackett, I know that this court is not bound by People v. Morse, but I think that the framework set forth in People v. Morse also serves the defense purposes.
But, counsel, here's my question.
Sure.
In the case at hand, you have a child, and the only way that you could try to explain to a jury that the child will be familiar with these horrible things is to be able to bring in evidence of sexual abuse. Not bringing that evidence in has an impact on the jury's ability to know or understand or comprehend how the child would have that knowledge. So wouldn't that be a situation that you're really limiting the defendant's ability to put on a defense? And if that's the case, help me to balance why that would be.
Well, in Arenda and also in Hackett, the defendant's ability to cross-examine or present a defense is not an unfettered right. And the legislature has obviously determined in enacting the Rape Shield Act that these issues of victims' privacy are relevant, legitimate interests. And that's why the court, even under the Rape Shield Act or under Hackett, can engage in that balancing test. And I agree with you. There is some value to the defendant of bringing in this prior sexual assault on this victim, because this defendant will hope that the jury will think the child might be confused or might be confusing the facts of the cases. But what's important is the difference between the prior sexual assault and the present sexual assault and the details surrounding that. And this victim was very, very detailed as to what happened to her at the hands of the defendant, where it happened, the surrounding circumstances, the
What
fact
kind
that
of briefs he was wearing.
exactly his Christmas boxers, which It seems like a silly detail, but there are only so many ways that a child can be victimized, and so we look to the details in determining their credibility. And she was able to describe his Christmas box, or she was also able to describe, and I think this is a significant point, that he applied lotion to his penis during the sexual assault. And when you look at the facts of the prior case, where her stepfather molested her, he molested her in a lot of similar types of penetration. But applying lotion to one's penis is kind of an unusual activity that she would not have been able, the defense would not have been able to rebut that very specific, very pertinent detail by bringing up the prior. And I think that the concern about presenting the defendant's case and his right to confrontation is adequately dealt with in Hackett with the balancing test. And again, in the Morse case, I don't disagree with you, Justice Bernstein, that it certainly does have some logical relevance, but the question is legal relevance. And when the legislature enacted the Rape Shield Act, there were certain purposes to prevent this inquisition into one's sexual past and to prevent embarrassment.
Let's turn to the issue that has divided the court for some time in determining whether the conduct referenced here refers only to the volitional sexual conduct or whether it more broadly encompasses any kind of sexual activity. Why would we choose one construction over another? What leads us one direction versus the other?
A number of different considerations. I think you can look to the text of the statute. You can look to the legislative intent. You can also look to other states.
Well, the legislative intent, where do we find that?
The legislative intent, and when I say legislative intent, I'm referring to their purpose in enacting this so that we don't
Where do we find that?
Find it, you mean written down somewhere?
How do we know what it is?
Yeah.
Well,
I mean, we have 110 representatives,
Right.
38 senators, and a governor. What's their collective legislative intent? Where do we find that?
I
Can we
understand.
go over and interview them?
I agree. I think, though, one thing you can look at is the fact that the wording of the statute initially referred to consensual sexual assaults. The wording was changed to sexual conduct. I think that change in wording tells us they intended a more broad scope of victims to be covered by the Rape Shield Act. But as far as, I agree with you. You can't go out and interview each one of them, but you take some clues from that. One of the other things that I came across in briefing this is reviewing some of the other states that have the exact same wording for their Rape Shield Acts. And their courts have interpreted it to include victims of sexual assault or non-volitional conduct. The states that have not, that have said, no, our Rape Shield Act doesn't cover prior sexual assaults, those states have been more specific in their wording. They have used the word consensual in the statute, or they have used a list of types of conduct that could be admissible. So I think that...
So you think it's fair to say that when this child was abused by her stepfather, and I assume that that's been demonstrated, is that right?
Yes, it has. Her stepfather was...
Conviction.
Right.
There was a conviction.
Yes, it was. It was a
She
plea.
was abused by her stepfather. It would be a fair characterization to say that she engaged in sexual conduct because she had been assaulted by her stepfather. That would be an accurate and an ordinary use of the phrase sexual conduct, that this victim, this young child, had engaged in sexual conduct in the course of being raped by her stepfather.
She did engage in sexual conduct with her stepfather, and I think
Well,
she
that's
engaged...
the issue, whether that's a
Yes.
natural understanding of the word, of the phrase sexual conduct or not.
And I think when you look at the definition section under the Rape Act in our statute, actor is defined as a person accused of criminal sexual conduct. Victim is defined as the person alleging to have been subjected to criminal sexual conduct. So the word sexual conduct, or excuse me, the words sexual conduct are used to describe both of these parties.
But is it the same to be subjected to it than engaging in it? Do you view subjected to and engaging in as about equivalent?
I think that being subjected to conduct and engaging in conduct is more a matter of one's choice, but I don't think that you can say that just because you're forced to do something, and the specifics of this case, I know the court's concerned with more than just that, but this particular victim, when she, in the prior case, it wasn't as if she was just raped. She was forced to perform oral sex, to perform sexual
how does that
touches.
inform
help
this
your- I mean,
discussion?
yeah, she's still, you're not saying some of that was like voluntary, right?
Oh, no. I'm not saying it was voluntary at all, no.
The
and
phrase we're trying to construe is evidence of, quote, the victim's sexual conduct. In what sense did the victim here have sexual conduct when she was raped by her stepfather?
In that she was involved in the activity. It may not have been her choice, but I don't think that the use of the word conduct implies that you have to be willing and consensually participating, because the statute doesn't say that. I think it reads something into the statute that's not there.
But it's not just that it says conduct. So if you said conduct involving sexual acts with another person, maybe. But this is the victim's conduct, suggesting that she has ownership of it, that it is her volitional act. Doesn't that make a difference?
It does, if that's the way that you read it. But if you also look at it like the victim's sexual conduct, when victim is defined as being someone subjected to that sexual conduct, I think that it encompasses both victims that choose sexual conduct and victims that are subjected to sexual conduct. And I base that on the definition section. That word was used both to talk about actors, who are people who choose to engage in sexual conduct, and victims who don't choose to engage in it but are forced or perhaps are unconscious or unaware that this is happening. I think that the term sexual conduct is broad enough to encompass both of those, and I think it would be...
Even you use the term every reference you've made to the term is she was exposed to criminal sexual conduct. She was the victim of criminal sexual conduct. I don't think anyone disagrees that that's an apt use of the term. The question is whether the specific context and use of the term sexual conduct in the statute, which I suggest is distinct from the manner in which you use it, is an appropriate use, is appropriately understood to refer to what she herself is engaged in.
And I guess my response to that, Your Honor, is I question why other states with similar wording have concluded that these victims are covered by this.
That's not the most compelling argument.
That's a different argument, and maybe it's your best argument. I mean, you wouldn't talk about this victim like to your mom or your friends or some non-lawyers. Like, sometimes we can like take off our lawyer language. And
Right.
You wouldn't talk to regular people and say, when she was raped by her stepfather, she was having sex, she engaged in sexual conduct. None of us would talk about that way. So, the question is how to understand it in the context of this statute. And maybe what you're saying is, it is a little weird, but it's the way every other court has gone. It's the way it's been understood in this state for a long time. And so it would be, and the legislature hasn't sought to clarify that it shouldn't be understood that way. So it might be disruptive for us to come to a different conclusion now. Is that part of what you're saying, or do you really think she engaged in sexual conduct when she was raped?
I don't think she willingly engaged in conduct. I think she was involved in activity. And I understand your point, Your Honor, and I think perhaps you worded it more succinctly than I would. But in order to be clear, I would add to that also, I don't think that this reading of sexual conduct as excluding people who are involved in non-volitional sexual conduct really gets to the reasons behind the Rape Shield Act. I mean, the reasons behind the Rape Shield Act are to protect the victim's privacy, to protect against harassment, to protect against misleading the jury. And I think it's illogical when you look at what happens if you read the statute the way that the court seems to be doing right now. We would afford more protection to someone who engaged in consensual sexual behavior or activity or conduct, whatever word you want to describe. And we would be giving...
A sexual worker, for example.
I'm sorry, could you repeat it?
In the politically correct term of the era, a sexual worker or a prostitute would have greater protection than a child who was sexually abused.
Is prostitute a bad word?
It's not politically correct any longer, I think.
And I think that hits the nail on the head, Chief Justice Young. I think that is the wrong result here. If we have a statute that is designed to protect the privacy of victims, why are we parsing it out?
But the reality is whether that is a felicitous outcome or a bad one is irrelevant to whether we're accurately giving meaning to the text of the statute, correct? The legislature can choose to give a prostitute greater protection than a child sexual assault victim.
They could, and if they had chosen to do that here, I think that they could have used the same language that other states have in actually putting the word consensual in it, but they didn't. and they haven't. And this court has had...
Perhaps they didn't because they didn't think it was necessary. The purpose of this statute, and I agree, it's always difficult to, assess what the legislative history of a law was apart from looking at its language. And I suggest its language is quite consistent with what almost unanimously seems to be the history of these kinds of statutes in the 1970s and 80s, and that was to generally prevent adverse character inferences. It was to protect the kind of aggressive search for aspects of a victim's history that would cast aspersions upon her that were irrelevant to the issues in the case. Those aspersions, those adverse aspersions, are not in existence when you're looking at rapes of a woman, because those are not generally viewed as having any consequence for her character. It's only when we look at her voluntary character, her voluntary actions, her volitional actions, that the risk is there that we're drawing some character inferences about that victim that really are just part of a fishing expedition that are not generally viewed as relevant to whether or not she was the victim in the instant case. But when we look to relevant histories of sexual conduct forced upon her, I think the premise is that reasonable, fair-minded people will not draw any adverse inferences about her character from that information. Isn't that right?
I agree with you, but I also think that the purpose of the Rape Shield Act does touch on... May I finish? Okay. Does touch on also the embarrassment of victims and undue harassment and things of that nature. And I think that a child who's been sexually assaulted is going to feel those same feelings of embarrassment when they're questioned about it.
Undoubtedly, these are very traumatic episodes, but we're always balancing in the process the rights of a presumably innocent defendant who shouldn't generally be deprived when there's a criminal sexual conduct alleged any more than when there's an arson alleged of the full opportunity to cross-examine and to question by whatever relevant evidence is available the veracity and the credibility of those who are accusing him of the crime.
And Hackett and Morse protect that right
They
adequately.
partly protect it, that's right, but not completely. You still would have to, even in light of Hackett, you would have to distinguish and make an exception for what would be relevant in the context of the Rape Shield Act. What kind of evidence would be relevant? You'd have to draw an exception from that kind of evidence that would not be relevant. You have a burden that shouldn't normally have to be undertaken by a criminal defendant in distinguishing distinguishing admissible evidence from inadmissible evidence.
And that is balanced against the privacy interests of the victims. I think they're competing interests. I think that the state of the law under Arenda is sufficient to address this issue.
Counsel, can I ask just one last question? Do we have to decide this issue in order for your client to win? Do we have to decide what conduct means? Or can you win some other way?
No, I think that, Arenda told us back in 1983 that these victims are included under the Rape Shield Act.
That's not the question she asked.
I'm sorry, I must have misunderstood.
The question is, do we have to reach this consequential construction issue or in order for you to prevail, or is there an alternative method by which, or an analysis under which you win without us doing so?
I think regardless of which way the court comes down on the Rape Shield Act, I think that this...
Do we even have to get there? That's the question. Take that off the table.
Okay.
Can you win?
Yes, because I think that even in absence of the Rape Shield Act, statute, when you talk about the overwhelming evidence against this defendant, whatever conclusion the court would have come to, or if they don't choose to come to any conclusion about the meaning of conduct, there was a wealth of information to show the guilt here. There was the other victim with strikingly similar incidents with the defendant. There was the fact that he fled, not just moved to Arizona, but fled. He was told that these investigations were going on and he took off, as well as this particular victim's very detailed testimony about this.
And another conviction in the state to which he fled for sexual harm against a child.
Yes, during the time, yes, while he was fleeing this investigation, he committed assaults against a third child.
I
All
find
that.
it very pointed, though, that you refer only to the harmlessness of the error, if there was in fact error here, when a great deal of the time spent examining your adversary was focused upon the relevance of the evidence. I asked several questions suggesting that maybe the evidence was irrelevant to this particular case, and she made her arguments for why it was relevant. You're not raising that at all here, so I assume that you think the evidence was in fact relevant.
No, I think that any relevance was marginal because I think that these incidents were very different.
Why wouldn't you raise that in response to Chief Justice Young's question or Justice Larson's question?
I'm not sure, Your Honor. I was focused on different aspects, but I do think that when the court has to decide whether or not it's relevant, they have to look at the similarities between the two situations, and the similarities, other than the fact that there were the same types of penetration, were very, very different.
Well, I guess I'd like to know at least why you disagree with your with adversary counsel about the relevance of this evidence. I suggested that maybe the evidence wasn't relevant for various reasons. She responded and said, yes, it was. What do you disagree with what she said about that?
I disagree with her characterization of the evidence as relevant because I don't think that the prior sexual assault on this victim can fully rebut what she was testifying about with this defendant.
It doesn't have to fully rebut nor to be relevant.
It doesn't, no, not to be logically relevant, but I think to be legally relevant, there has to be some significant connection there, and these were two very different incidents. There were things that she testified about that Mr. Duenaz did to her that could not be explained or even lessened by pointing to the fact that she was sexually abused before. The only purpose in that would be such as the Christmas boxers, such as the details of his room, such as the fact that he put lotion on his penis. None of those things are going to come about because she was previously assaulted, and I think that the only reason why the defense would have wanted to present this is to show her as a confused child that just doesn't know what she's talking about, and I think that that's exactly what should have been prevented in this case.
What about the age and appropriate evidence?
The age and appropriate evidence, when she disclosed at 8 years of age, I would not say that the words that she used in her disclosure were inappropriate for her age. She was not using vernacular that would be any different than any other 8-year-old. I mean, she's using commonly used terms to describe body parts. I don't think it was age inappropriate at all at the time of disclosure, and certainly not at the time of trial when she was 12. So I don't think that there would have been any relevance in bringing that in on age inappropriate knowledge, particularly in light of the differences between the two situations.
Thank you.
Thank you.
I think going in response to your question and your question with respect to why the evidence, there was only evidence that would support the complainant's version. And there's been a few references to Christmas boxers. Her statement was the only evidence that was introduced that he had Christmas boxers. And with respect to the description of the room, there's no dispute that she had been there.
This was the only testimony that he used lotion on his penis either.
That's certainly true. But if to point to the Christmas boxers as being a detail that proves the case and makes this the other evidence of the previous assault irrelevant, it should be considered that was her testimony. It's not like there was a pair of boxers introduced to say, yes, he owns boxers like these. Going back from that and getting to the question of sexual conduct and sexual activity and the statute.
Wait a minute. You're saying the lack of corroboration makes more relevant the fact that she was previously sexually assaulted?
No, but to say it's irrelevant because she had details that she could only have known because of this particular assault as opposed to a previous assault, there is not. So
there was no identity to this. These are all generic. Her testimony about the nature of her sexual assault, you were saying, were generic. They could have been perpetrated by any male? I'm not saying that it's necessarily generic. What I'm saying is that knowing the details of a... Unless that's the case, then I don't understand. Unless you're saying her testimony about her sexual assaults were so generic that the fact that she'd been raped before might be relevant because they could have applied to either. it seemed to me there was a high degree of identity to this defendant in
Well,
her testimony.
The identity is that she had been in his room. That's why she could describe the details. There's no debate that she had been in his apartment and that she had gone there to bake Christmas cookies. The dispute was about whether or not the assault had occurred. And so with respect to the relevance of the previous information and in not rebutting everything entirely, which, as you correctly recognize, is not the touchstone for relevance, the things that Sister Counsel pointed to are not necessarily these details that could only have been true because this assault occurred. But if I could get to the point about sexual conduct, sexual activity, the statute, this statute provides equal protection to every victim of a sexual assault. And that's the point of it, whether than keeping out the past. It's not that you're providing greater protection to prostitutes or sex workers, but you're providing the same protection. And that getting
Wait a
into...
minute. Depends on who you are and what kind of sexual history you have.
No, it's
Because
the-
if you're a sexual worker, if you're a prostitute, you're having perhaps illegal but consensual sex. But if you've been a victim of sexual assaults, the prostitute's history doesn't come in under your preferred construction, but the history of sexual assault does. Those are asymmetrical.
Well, you're providing the same protection with respect to past sexual conduct. If you view it as that you're keeping out conduct, which is a broader term than activity, right? The statute defines activity with respect to particular, much more physical acts, right? Within the subsection, I think it's B, sexual
But
activity.
it defines victim as being the subject of sexual conduct.
But that's because that's the act of that's the act. Assault. Let me put it this way: if you take out the word sexual and you talk about assault, right? If a person is a victim of an assault, that is not their assaultive conduct.
Correct.
So any more so than if you're the victim of a sexual assault, that this is your assaultive conduct or your sexual conduct. That the terminology was intended to be broader, to keep out the sexual history, the types of questions about things that a person may have done that would have invited an attack, right? And
No,
that's why
I thought the generic, as described by Justice Markman, was to prevent the harassment and humiliation of being subjected to questions about one's sexual activities, or history, and the assault of having to do that in the context of you accusing somebody of having assaulted you in a trial.
But it keeps out this broader history of what you may have consented to in the past and what you may have done. With
So
respect
somebody
to,
who's been assaulted has greater likelihood of having to deal with that kind of confrontation than the person who's had a history of voluntary sex. Is that
no,
correct?
because you still have the same protections of 403, the relevance, right? You'd have to show the relevance of
But
it.
we're
You
talking
have
about
to-
what protections the rape shield statute affords, not what other rules of evidence afford.
It was to keep out character inferences, wasn't it?
Right, well, and the statute is phrased that way,
I mean,
right?
whether
Opinion evidence.
you can't rape a prostitute either is the whole point. I mean, prostitutes have rights as well. And
That's what I hear.
the point is, we assume that if a prostitute has been subject to rape, a character inference would not be drawn from that fact alone, but to point out that she has been in the commercial business of selling her body may have no relevance whatsoever to whether or not she has been subject to some kind of violent sexual attack in the instant case.
Correct.
So the more egregious episodes, that is when a woman, for example, has been subject to a rape, a violent attack, that doesn't raise any adverse inferences in a normal situation about the character of that victim. But when we talk about her having dressed provocatively, or we talk about her, being out with a different man every night, those are things that are generally not going to be relevant, but that do raise adverse character inferences.
And would be described as sexual conduct, but not sexual activity.
Do
And that's
you concede the point that there is no character concern that is raised when cross-examination is directed at a prior rape? Do you think that's a neutral inquiry that, for which there are no adverse inferences that a jury could draw? Is that your position?
My position would be that it certainly is not a bearing on, that it no more so than being the victim of any other crime would be an adverse inference. I mean, there can be reasons you don't want to talk about it, and that gets to the harassment and other parts to it, but it doesn't make it a person's sexual conduct.
Thank you.
We don't talk about a person's reputation, for example, for having had his home burglarized on many occasions. That's not how we refer to people.
Right.
He may have a reputation for certain things that he's done in the past, but we don't generally refer to somebody as having a certain character or reputation based upon the fact that he's been victimized by some crime, whether it's burglary or larceny or anything else.
Right.
Thank you. The case is submitted.